The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning and welcome to this remote oral argument session of the North Carolina Court of Appeals. I'm Judge Richard Dietz and I'm joined by my colleagues Judge Jefferson Griffin and Judge Darren Jackson. There is one case on the calendar for argument today, and that is number 2046, State of North Carolina XREL Utilities Commission versus Cube Yadkin Generation LLC. I'll just say for the benefit of the public, Judge Dillon was originally presiding over this case. There was a recusal. I'm now presiding on this panel, and I apologize to the public that we were unable to update the public calendar in time, but this is the panel composed for this case. With that, we've confirmed that the parties are ready to proceed, so we'll hear from the appellant.
Thank you, Your Honor. May it please the court, I'm Jim Phillips with the law firm of Brooks, Pierce, McLendon, Humphrey, and Leonard in Greensboro. I'm here with my law partner, Marcus Trathan, and with Giselle Rankin on behalf of Cube Yadkin Generation LLC. I'd like to reserve 5 minutes for rebuttal. We're here because on September the 4th, 2019, the North Carolina Utilities Commission decided to act as if it were the North Carolina General Assembly and rewrite NC Gen Stat 62-323D to suit its own policy preferences, rather than applying the plain language of the statute to Cube's petition for declaratory ruling. As a result, the Commission committed reversible error, acting in excess of its statutory authority. This court reviews questions of law de novo, and it should reverse the Commission's order. Cube is in the business of acquiring, modernizing, and developing hydroelectric facilities. And to be clear from the start, it is not a public utility under North Carolina law. That is undisputed. In 2017, Cube acquired from Alcoa 4 electric generation facilities on the Yadkin River that had for almost 100 years powered Alcoa's smelter in Baden, North Carolina. At the same time, Cube acquired a substation located at the Baden Business Park and 17 miles of transmission line that run between the generation facilities and the substation. Since Alcoa shuttered its smelter in 2007, removing all of what had been over 900 jobs just a decade before, the town of Baden and Stanley County have struggled economically from a lack of jobs and a loss of tax base. Cube proposed in its petition for declaratory ruling to utilize its assets to attract tech-based industries that need real estate, clean, reliable electricity, and other services to Baden Business Park. Specifically, Cube proposed to acquire or lease the Baden Business Park and to lease space there to tenants who would create jobs and pay taxes. Cube provided to the Commission, as part of its petition, a lease template showing that it would provide typical landlord services such as space, tenant improvements, maintenance and property management services, and utility services, electricity, water and sewer, broadband, all for a flat bundled rate. The lease also makes clear that the utility services will not be separately metered, and that the tenant may not resell those services. Cube sought a declaratory ruling from the Commission that if it proceeded with this course of action, it would not be deemed a public utility under Chapter 62. Applying the plain language of Chapter 62, and in particular GS 62-323D, and prior rulings of the Commission to the facts set forth in Cube's petition, it is clear that Cube should not be deemed a public utility.
Counsel, let me stop you there and ask about the justiciability question, because I think it makes sense to just address that before we get into the merits here. So let me ask you a hypothetical. If, much like with your lease template, if a litigant came to court and said, here's a proposed contract that I'd like to use to enter into a contract with another party, court, can you tell me if this would be enforceable? What would the court say about whether we can issue a declaratory judgment there?
Your Honor, I would want to know the facts related specifically to that circumstance, but here GS 1-254 is clear that, which is a portion of the state's Declaratory Judgment Act, it is absolutely clear on its face that any person whose right status or other legal relations are affected by a statute, and that's what's at play here, a statute, may have determined by any question of construction arising under the statute and obtain a declaration of right status or other legal relations hereunder. And 1-264, 10 sections later, also a part of the Declaratory Judgment Act, states that its purpose is to afford relief from uncertainty and insecurity with regard to rights, status, and other legal relations. And it is to be, and this is important, liberally construed and administered. That should be enough, I think, Judge Dietz, to end the inquiry. And it was for the commission, which Duke made the same argument below, and the commission didn't even address it. And you'll recall, if you've looked at the 4 commission orders, the Catawba petition from Catawba County was very similar to the one that Cube posited. There, Catawba County was about to spend $12 million to do the things that it wanted to do. And before it went forward, it came to the commission and asked for a declaratory ruling that it wouldn't be a public utility. This is precisely what the Utilities Commission does on a regular basis, and it's an important service. The last thing I'll say, Judge Dietz, is that look at the North Carolina Warren case. In the North Carolina Warren case, North Carolina Warren went out and put a solar system on top of a church without asking for a declaratory ruling. Duke contended specifically, it chastised North Carolina Warren for not having sought commission guidance before it did, and argued that North Carolina Warren should be penalized $1,000 a day. Ultimately, it was penalized $200 a day. So I think that this case is squarely within the Declaratory Judgment Act. It is exactly what the commission does over and over again.
So just one more follow-up, which is I think one argument we might hear from your friends for the appellees is that it's certainly the case that you can come and ask for declaratory relief to interpret your rights under a statute. But the problem here is that there's more information needed about precisely what your client will be doing in order to figure out whether the landlord-tenant exception applies. And that's part of the problem here is there's a ripeness issue because there's some fact-intensive questions and you can't really know some of those answers until you actually see what is happening on the ground. And so I assume your position is that's not true. What we've provided to the commission is enough to answer the question. But why don't you explain why you think that?
Your Honor, I do think that. The Cube provided a lease template to the commission, which showed exactly what it would do. Cube articulated in its petition that it intended to buy the land or lease the land, and these would be the terms of its lease with any tenant. And I believe that the lease itself lays out the plan that Cube had and enough for the commission to make a decision. One of the reasons that's true, I think, Your Honor, is if you look at the lease landlord-tenant exception in 23D, it's not complicated. The question is there a landlord? Is there a tenant? Can the tenant resell the electricity? Will the electricity provided to the tenant be separately metered? Those are the elements of the 23D exception. The commission itself said there's no legitimate issue as to Cube's status as a landlord. And Cube's lease showed satisfaction of the other issues. So we believe that absolutely the requirements were met and that there are no factual issues.
Let me turn to another hypothetical, because I've got several questions here. I don't want to cut you short on time for making your argument. So one issue I had in this case is I wanted to test how far your statutory interpretation argument goes. So suppose you have a utility company called Jones Electric, provides power service in lots of counties. It spins off its Stanley County operations to a subsidiary that then splits off into its own company. And through a huge debt offering, it buys up all the land in Stanley County and then just says to every single person that consumes power in the county, you're just going to lease from us instead of owning your property now. And then says, well, and we're no longer a public utility because now we're just a landlord. Is it your position that that the statute permits that the commission would then say, you're right, this power company is no longer a power company?
So, Your Honor, under your hypothetical, and I must say I probably didn't get all of it, but I get the point of your question, I believe, which is, quite frankly, does size matter? That's, I think, what you're asking me. Is this larger than the landlord-tenant exception would allow? And I think the answer is no, at least with regard to Cube's proposal when you look at the landlord-tenant exception. Nowhere in 23D is there a limitation on the landlord-tenant exception based on the size or volume of the utility services provided. As the public staff,
But I think the challenge is, in my hypothetical, the challenge is someone reading the statute would look and say, well, this new Jones Electric spinoff in Stanley County is otherwise a public utility. And so it just happens to have bought up all the land so that it can no longer be regulated as a public utility. And my question is, do you think that this is just a loophole that applies to anyone, or is there some reason why your client is different than that sort of scenario, regardless of how large the operation becomes, or whether your client's primary purpose is to generate and furnish the power, and then the sort of incidentally, you'll be a landlord?
So, Your Honor, if I understand your question now, what you're saying is that Jones Electric is otherwise a public utility. And if Jones Electric is otherwise a public utility, then the exception doesn't apply. I mean, the commission has already determined in a 1995 proceeding, NRA Wireless, I believe is the name we've cited in our brief, that the purpose of the not otherwise a public utility language is to ensure that a public utility is not inadvertently deregulated as a result of meeting one of these exceptions. So if Jones Electric is otherwise a public utility, if Cube were otherwise a public utility, then it would not qualify for the exception.
Well, my hypothetical, this spinoff company is now a landlord. So I thought your interpretation was at that moment then, so it's not a public utility because the exception, according to your interpretation of plain language, would apply. So what difference would it make if it used to be a public utility when it was part of the larger company? That's sort of what I'm getting at is, because I think your position is you can't ask the question sort of hypothetically to the landlord tenant. You're supposed to be backward looking to see if they're otherwise a public utility, or am I misunderstanding your argument?
That is exactly right, Your Honor. Not otherwise a public utility looks at the other things that the landlord is doing. If it doesn't, if it is otherwise a public utility, the exception doesn't apply. If it's not, and it qualifies under 23D, then it can take advantage of that exception. So if Jones Electric is now not otherwise a public utility, if it has somehow managed to do that, the question is looking to the plain language of the statute, which is clear and unambiguous. There are particular things that have to be met in order for the landlord-tenant exception. And the error that the commission made was not to do that. The commission chose instead to apply 23A and to spend 10 pages discussing the Simpson test for whether utility services are being sold to the public. That was an erroneous that was an erroneous way to go about this analysis. If you look at the 4 cases that we cited to the commission and to the court, where the commission has undertaken the landlord has taken a look at the landlord tenant exception, the point of those cases and the reason we cite them is not for their outcomes. You'll note that in 2 of those cases, the commission determined that the landlord tenant exception did not apply. But what is important about those cases is the analytical framework that the commission applied to make the decision about whether the exception applied. In none of those cases did the commission apply the Simpson analysis to the proposed conduct. In none of those cases did the commission say that the exception was limited to a narrow circumstance where the landlord buys from a public utility and then provides to the tenant. In all of those cases, the commission did what Cube urges here. It examined whether the proposed conduct met the criteria in 23D. The purpose of an exception is to remove something from the general rule, here the general definition. And 23D removes the furnishing of utility services by a landlord to a tenant from the definition of public utility. The Simpson analysis at bottom is a red herring. It's irrelevant. And its application here effectively writes the exception out of the statute. As a rationale for choosing the Simpson analysis as its root, the commission stated at page 202 of the record that 23D says the exception does not apply to any person, landlord or not, who is a public utility. But that's not what it says. The exception says it applies when the landlord is not otherwise a public utility. And as I've said, that means you look to the other things they're doing. The record is clear that anything and everything else that Cube does now does not make it a public utility. So it qualifies for that exception.
What if we thought that in order to harmonize your argument and your friends for the appellee's argument here, we look to what the primary imagining there is no landlord-tenant relationship, what is the primary purpose of, we're sort of separating them out, what is the primary purpose of the company that's offering these services? And if we conclude that it's that it is power generation and furnishing that to people who need that power, and then the other things going on are incidental, so that would prevent the extreme, the power company that can deregulate by buying up all the land scenario. But someone who is primarily a landlord and the power provision is incidental, that's okay under the statute, and then make it a fact-specific question for the commission. What would you oppose that?
Yes, Your Honor. I think that the exception doesn't say anything about what the primary purpose of the landlord is. The exception is straightforward. And the utilities and the public staff, which is statutorily charged with the representation of the using and consuming public, responded specifically to that argument made by Duke and others in its filings with the commission. What they said there is North Carolina General Statute 23D is not limited to leasing arrangements of particular scale and scope. That is a distinction that makes no legal difference. And Your Honor, if you look at, as I said before, early in responding to your questions, 23D has nothing in it about size or volume of services provided. And the fact that that's not relevant here is confirmed by other portions of Section 23. If you look at Section 23A2, it contains an exception for the sale of water, but only to less than 15 homes. If the General Assembly had intended to limit the size or scope of the landlord-tenant exception, it could have done so in 23D, just like it did in 23A2. the fundamental answer to your question, Judge Dietz, is that the arguments that Amici and Duke are making are policy arguments that should be made to the legislature. If the legislature wants to change the statutory exception, it can. But you'll note that in Section 23, A through N, there are 13 subsections. 8 of them contain exceptions to the statute, all of which are judgments made by the General Assembly as to what should and should not be denominated as a public utility. It's not just landlord tenants, it's co-ops and homeowners associations and hotels and a variety of judgments applied by the General Assembly. The argument that that Duke makes here is an argument for the General Assembly, not for the court.
So it's your position that if $1 billion company came in and bought up land, constructed huge infrastructure, power generating facilities, and then provided power to entire communities, towns and factories and everything, as long as they were the landlord, because they were all rentals, they were all lease agreements, that could be permissible. But if a Duke or some other utility did the same thing, that would be prohibited under the statute. And if that's your interpretation, how does that make sense when we look at all of the provisions of and the reason that we have the Utilities Commission and these laws to begin with? I mean,
Your Honor,
why allow that $1 billion company that's building out and competing with Duke to avoid this regulation and not our regulated utilities?
So, Your Honor, with regard to the $1 billion company, I don't know the specifics of what it's doing, and it's hard to answer that particular hypothetical. But what I do know is this: the statute is plain on its face. It's clear and unambiguous. The North Carolina Utilities Commission has said that when you want to determine, it says this in American Homes for Rent, when you want to determine whether a provider is a landlord or is not a landlord, the only section of the statute of Chapter 62 which tells you unequivocally and plainly is D3, and that is 23D, and that's where you look. Your Honor, I also think in addressing whether it's your $1 billion company or whether it's Cube, the critical starting place is the North Carolina Supreme Court's decision in State Ex Rel Utilities Commission versus Lumbee River Electric. And the Utilities Commission, I think it's noteworthy, and this is talking about the analytical framework. The Utilities Commission relied extensively on that holding and the statutory construction provisions there in making its determination. So what happened there is that somebody came asking for a 23D exemption. And in construing 23D, the court cited to Utilities Commission versus Lumbee River. In that case, in Lumbee River, the Supreme Court explained that when a section of a statute deals with a specific situation, and that specific situation is at issue, as it is here, that section of the statute controls over general sections, over sections of general application. As to that specific situation, it's regarded as an exception to the general rule. The court went on to say in Lumbee River, and I think this is particularly important with the in para materia and your question about the overall purpose of the utilities statutes. The court went on to say, and I quote, "It's true, as contended by Lumbee, that when statutes deal with the same subject matter, they must be construed in para materia and harmonized to give effect to each. When, however, the section dealing with the specific nature, the specific matter, is clear and understandable on its face, it requires no construction. In such case, the court is without power to interpolate or superimpose conditions and limitations when the statutory exception does not itself, which the statutory exemption does not itself contain. And I think that, quite frankly, the arguments that Duke makes about size and otherwise seek to have this court interpolate or superimpose conditions and limitations which the landlord-tenant statute itself does not contain. That is directly contrary to the teaching of Lumbee River. After citing that proposition in American Homes for Rent, the commission went on to find that 23D is clear and understandable on its face, and therefore the commission must be guided by 23D, the specific statute, in making a decision in this case. So, Your Honor, I believe that despite all the hypotheticals, regardless of size, the plain and clear language of the statute 23D applies. I'll reserve my 5 minutes. Thank you.
All right, thank you, counsel. We'll hear from the appellee.
May it please the court, my name is Dwight Allen. I'm appearing on behalf of Duke Energy Carolinas and Duke Energy Progress. They are the two operating utilities companies in North Carolina that are owned by Duke Energy Corporation. I want to introduce the people who have worked for me or helped me with the brief, Britton Allen and Brady Allen. I would like to state as a matter of personal privilege, I've known these two young men a long time. In fact, my wife introduced me to them in the delivery room at Nash General Hospital in Rocky Mount. So there's a family relationship there. And in addition, Lawrence Summers, who is Deputy General Counsel for Duke Energy, also participated on the brief. Before I get into my principal argument, I would like to respond to some of the things that were made by counsel for Cube Yadkin. He said the commission is trying to legislate and change the statute. The truth is the opposite is true. And the commission in its order said, we are not going to legislate that third-party sales are authorized in North Carolina. And fundamentally, this is just another effort by Cube Yadkin to engage in third-party sales, which this court said in the N.C. Warren case was widely understood to be banned in the state of North Carolina. So to the extent Cube wants to do third-party sales, they need to go to the General Assembly and have the General Assembly change the policy. That has been viewed many times as the N.C. Warren case indicated, but so far the General Assembly in its wisdom has decided that the regulatory construct that we have in Chapter 62 should be maintained. As to the justiciable controversy, the commission does use the Declaratory Judgment Act frequently in deciding cases, or people file them under the Declaratory Judgment Act. Sometimes the commission says it's justiciable, sometimes they say it's not. And the reason I think it's used there a lot is because most of the things that the commission is engaged in involve highly capital intensive businesses. So it's natural that a business would like to go in and get advisory opinion from the commission in order to eliminate the business risk it's going to incur if they engage in a certain business. But the Declaratory Judgment Act is not designed to insulate business from taking business risk. Now, when counsel for Cube likens this case to the N.C. Warren case and says it's the same, let's take a quick look at that. In the N.C. Warren case, it was actually a test case. It was stated by N.C. Warren as a test case to determine whether or not they could engage in third-party sales. But N.C. Warren, we knew who the church was. We knew how big the generating unit was. We knew where that generating unit was located. We knew what the price was and what they were going to be charging. In fact, they were already operating that unit when they petitioned the commission for a declaratory judgment. In this case, we don't even know who the church is. We don't even know if there is a church. We don't know what kind of business the church is going to be in. We don't know what the load factor of that church is going to be. And of course, I'm using the term church loosely. It would be a big business, according to the petition filed by Cube Yadkin. It would involve high load factor customers, not just the 216 megawatts that Cube Yadkin is able to generate, but they want to be able to go out on the open market and buy almost twice that amount, import it into North Carolina, and resell services that they buy at wholesale prices. This case stretches the use of the Declaratory Judgment Act almost beyond reason. If you take a look at the Exhibit 1 to the response that Duke Energy filed, there is a PowerPoint presentation that Cube Yadkin presented to the public staff. On that PowerPoint presentation, there are a number of marginal notes, which the record shows were made by attorneys for the public staff. The attorney for the public staff indicated in there that there were a number of factors they needed to find out before they pursued this thing. Interestingly, one of those things says we need to notify Duke of this and see what they have to say about it before it's presented to the commission. None of those things were ever followed up on, and Duke was never notified. And as a matter of fact, this thing went on the commission's agenda Wednesday before Easter Monday to be heard on Wednesday before Good Friday to be heard on Easter Monday. In the hypothetical concerning Jones Electric, Judge Dietz, I think that's a very good hypothetical and tells us fundamentally why Cube Yadkin has misread this statute. What they are saying is, if Jones Electric went in there and became a landlord, and they only owned the facilities that they were going to lease, but at that time were not otherwise engaged in a public utility business, then after they acquire those assets, they can do anything they want to. They can become an unregulated monopoly with captive customers who have no option but to get service from them. The commission correctly decided, no, that's not the way you look at this.
Well, your friend for the appellant,
otherwise a public utility, it means what are you going to be doing once you start doing the activities that are included in Section A of GS 62-323, which defines in A1 what an electric utility is, and in A2 what a water utility is. And to a large extent, those two standards are the same. So,
well, counsel, I heard your friend for the appellant actually embracing my hypothetical and saying that's essentially that's right, that as long as looking backwards, you were not otherwise a public utility, which my hypothetical, the spinoff Jones Electric would not have been, then you can do that. And it may appear to be a loophole, but it's what the statute permits. And so let me ask you about that. One argument about examining, so I understood your argument to be strip away the landlord-tenant relationship and examine what's really going on here. And is this entity otherwise a public utility? And your argument is, well, and of course here that is the case because this is a business is primarily generating electric power. And my question is, but wouldn't, if you stripped away the landlord-tenant relationship, wouldn't also a landlord just providing the power as sort of an intermediary to all of the tenants in an apartment complex also be a public utility? Because, you know, reselling that electricity to the tenants would subject it to regulation. Am I wrong about that?
well, they would be a public utility if they were reselling energy. And in terms of whether you're providing it for compensation or not, it doesn't really matter whether it's service that is being provided on a flat rate basis, whether it's being included in the lease amounts, or whether it's being measured by some meter. But in the commission cases, that Cube cites, and I will note two particularly, two that they listed in their brief, their reply brief. One is in race Stafford, and the other one is the campus Raleigh case. In the in race Stafford case, the commission said when you are furnishing electricity, you have to get that electricity from the regulated utility. And you furnish that to your landlord, to your tenants under some basis which is simply a pass-through and does not provide for additional compensation for you as a public utility. In the Campus Raleigh thing, they even went further to say that you can be a landlord, but you can also be a landlord that is a public utility. And if you're a landlord providing public utility services, which is generation and transmission and distribution and furnishing, then you are a public utility. You can't just look at it as what happened prior to the time the landlord decided that in addition to being a landlord, they wanted to be a public utility. You've got to go to that next step. What Hugh Yadkin said to the commission, we're a landlord, and we're a landlord who also happens to own all these other facilities, and we're going to provide utility services to our fictional tenants that we hope we will get one day. They don't have them now. And the commission said, well, you can't look at it that way. You can't stop that inquiry. You have to determine whether the landlord is a landlord who also is engaged in the business of providing utility services. If it's not to be interpreted that way, the regulatory construct that we have in North Carolina is absolutely destroyed. And you're going to have...
But getting back to my question, what I struggle with that argument is a business reselling electricity to people living in various units in an apartment complex would be a public utility under the statutory definition. So any landlord who is engaged in the business of furnishing to the tenants the electricity, without the exception, would be a public utility. So
Yes,
I'm having trouble figuring out how your argument works when you're saying, well, Cube Yadkin must be otherwise a public utility, but just the landlord of the large apartment complex would not be. So explain that to me.
Well, if you look at the way this statute is constructed, under A, we have a definition of public utility. And public utility, if you provide the things that appear in GS 63-323A1, basically an investor-owned utility service, providing utility service and public compensation, you are a utility. And then the statute goes down to make certain exceptions. Those exceptions are if you are a municipality. And the reason that's an exception is because you go to your town council to resolve your issues. If you're a cooperative, the reason that is not a public utility is because you're providing service to yourself. You're member owned. And as a member owned company, you go to your board of directors and they regulate things. If you are a homeowners association, you're providing service to yourself. And then we have the provision in subsection D. And that really was intended not necessarily to be limited to a landlord exception. It was a self-service exception. And if you go back to the definition under subsection A of what is a public utility, it says generating, transmitting, distributing, and furnishing. Subsection D talks just about furnishing. Now, Cube Yadkin says the language furnished in D means the same thing that it means in A. But that doesn't make any sense, because if that was what it was meant, then the self-service exception that is explicitly included in Section A would be unnecessary. And
So
you
let me
can't.
ask you about that because I didn't see your argument made quite this way, but are what you saying that that the exception should only apply to those who furnish electricity, but if you generate and furnish the electricity, then this landlord-tenant exception cannot apply to you? Is that your position?
Yes, it is. If you generate, transmit, or distribute. And as a matter of fact, if you look at the cases cited by
Well,
Cube
what
Yadkin,
happened to a landlord who put solar panels on the roof and used some of that power for the tenants as well?
well, a landlord would be providing, essentially providing service to themselves. And there's a whole nother section of the statute under 6B, Article 6B of Chapter 62 that deals with lessors of solar facilities. That was a bill passed by the General Assembly in 2017. So,
Right, but my point was just, what if the landlord was just generating a small amount of electricity and then also purchasing it and furnishing it to the tenants? Why wouldn't that be then the same as as uh, as Yak and Cube? Then in other words, why would the size of the power generation matter when looking at the words of the statute?
well, if the owner of the facility, the solar facility on the roof, was providing service to themselves, they would be entitled to the self-service exception. If they started selling at retail to people that were tenants or people within that building, they would be a utility under our statutes and would have to qualify as get a certificate of public convenience and necessity to operate as a public utility.
Okay, so that was something I was trying to understand. So your position is, if the landlord of the apartment complex is generating a small amount of electricity and then also buying the rest, providing it to the tenants, that by generating that small amount, they become they fall outside the exception, just as you believe the Act Cube does. But if they're just buying the power from someone else and furnishing it to their tenants, then the exception applies. That's your position?
And essentially that's what the commission has said. And that's what the commission says in its order. That's what appears in the concurring opinion. If you buy it from the regulated utility and you bundle it as part of a package to make things simple for you as a landlord in a apartment complex or wherever you might be, and you don't resell it, you simply pass it through, then the exception would apply to you. But of all the cases cited by Cube Yadkin, both commission cases, cases from Maryland, cases from Pennsylvania, although those two state statutes differ, there is none of those cases where it is even surmised that anybody who generates or transmits electricity is not a public utility. Generation and transmission in both the Maryland case and in the Pennsylvania case was not an issue. What they were simply doing was they were buying utility service from the regulated utility, packaging it, bundling, and providing it to their tenant on various bases.
So I think the response we're going to hear from your friend for the appellant is what you've described is a way to avoid the policy concerns that I was describing in my hypothetical, but it's just not what the statute says. And if that's what the legislature wants, it's for the lawmaking branch of government to do that, not for this court to rewrite the statute to make sure it achieves what we think are the policy goals of the General Assembly. And I think that there's a good point there that what we're describing about drawing this distinction between generating the power or having some predominant purpose of being a power generator versus just refurnishing it, essentially, buying it and then giving it to tenants, that the statute doesn't really say anything about that. So are you saying we should read that all from kind of examining in context this provision and the others in this section?
Well, I think you do need to read them all in context, and that's what the commission does. They basically said the arguments made by Cube Yadkin to saying not otherwise a public utility applies to the activities of the landlord prior to the time they decide to get into the utility business was disingenuous and very misleading. That's harsh words for the commission. I've been doing commission work for a long time, and I've never heard them say anything like that. And it really is a convoluted interpretation of the statute. Because if that is what it means, when you look down there at not otherwise, the only two parties in North Carolina that would be prohibited from being a landlord and becoming an unregulated monopoly would be Dominion and Duke Energy. And that clearly is an illogical result. And you have to make an illogical interpretation of the statute, in my view, to reach that result. And that's what the commission said. Obviously, they would not have written that exception in there, or the words otherwise in there, if they were only trying to prohibit Duke Energy and Dominion of North Carolina from being in the landlord business and being able to provide service with no regulation at all. It's just not a logical conclusion in our view. That responsive, I'll move on. The interesting thing about Yadkin is they have, since 2017, actually 2016, proceeded on 3 different scenarios. They are currently exempt wholesale generator under federal law. That's what they were when they acquired these assets in 2017. That's what they are now. That's what Alcoa was after they sold their aluminum smelting operation and quit providing service to themselves as an aluminum smelter. At some point, beginning in 2016, they approached Duke Energy and said, we would like to be a qualifying facility. Qualifying facility is a concept under federal law where people can generate electricity, sell it to the regulated utility who buys it at the regulated utility's avoided cost. The problem was that they were not forced to file a declaratory judgment in that case as they said they were, but what happened was they wanted to make their qualification as a qualifying utility relate back to 2016, and they said we made a firm commitment to provide the output of these dams, actually 3 of the dams, because one of them was not eligible to be a qualifying facility, and we want to provide that to Duke Energy as a qualifying facility. That case, on procedural grounds, it's reported in book 269, page 1. It's a decision of the North Carolina Court of Appeals. The court remanded that to the commission on procedural grounds. That case is currently pending before the commission, and in that case, Cube is saying we are a qualifying facility. Before that case, the ink had dried on the court's case. They then, in March 2019, filed a petition for declaratory relief and said, oh, no, we're not an electric wholesale generator. We're not a qualifying facility. Now we want to be a landlord, and a landlord that is exempt from regulation. The problem with all 3 of those is they are mutually exclusive. You can't be a qualified wholesale generator and also a qualifying facility, or a landlord that leases property and is a de facto unregulated utility. They're all mutually exclusive, and I think Cube, it seems to me what they're trying to do is they have bought these dams and they're seeking a business for them. The exception in subpart D was never intended for a producer, a generator, and developer of generating facilities to go out and solicit tenants And once they get those tenants, acquire real estate to create a market for the utility services that they were providing. It was to allow, if you are a landlord and you want to furnish, not generate, transmit, distribute, and you want to furnish electricity to your tenants, then you can do that, but you can do that only on a limited basis. And that is what the commission found. And we believe the commission was correct and that their order ought to be affirmed. In addressing the various cases that they cite at the commission, we do not believe any of those cases are controlling. In fact, the facts are very different. In all of those cases, the commission said these cases should not be interpreted as precedent. In fact, the law in this state is that they are not binding precedent. This court in the NC Warren case, and citing the Carolina Water Service case, so stated. They said the commission's decisions turn on their own facts, and it's not binding precedent for either this court or future commissions. But even if you look at the facts of those cases, as I've stated before, in all of those cases, with one exception, they found that what the people were proposing to do were regulated utilities. And they also said, when we look at this exception, we're talking about furnishing, and there is a difference between furnishing and the language in Part A, which talks about generation, transmission, distribution, and furnishing. And you have to give those words their logical meaning. And the commission says when you furnish, you buy from the regulated utility and you furnish. And the commission also says you can be a landlord, but you can also be a landlord who provides public utility services. And if you are just a landlord, that's fine. But if you are a landlord who also provides public utility services, as defined in Part A, then you are a public utility and you are subject to regulation of the Utilities Commission. And in our view, that is a logical and sensible interpretation of what that statute means. Now, Yadkin says this statute is clear and unambiguous, yet they go into very much detail in their initial brief to define what is meant by otherwise, what is meant by service, and what is meant by such. And they spend page after page after page talking about what those words mean. If this statute is truly clear and unambiguous, it was not necessary to do all that word parsing. And if a case is such that it's not clear and unambiguous, then you have to look beyond that specific statute. And this court has cited, and cited in the NC Warren case, the Edmiston case, that says you have to look at Chapter 62 in terms of the total regulatory construct that was intended. Specifically, that North Carolina and North Carolina citizens are better served by getting their services from a regulated utility that is subject to the jurisdiction of the Utilities Commission. And in that situation, you must look at all of those provisions of the statute and treat them with equal effect. You can't just isolate one and say the regulatory construct is limited to looking at a single statute. And in this case, we think that is true. Duke Energy, Dominion Energy, they operate in protected territories under the Territorial Assignment Act. They are required to serve all customers, whether they are lucrative customers or whether they don't recover the cost of providing their service. And as a benefit of that, and as the commission noted, they are entitled to serve additional future customers. Because if they're unable to do that, then the average cost pricing concept of regulation falls apart. And you start targeting individual customers based on the cost of providing service. There is no way, and in the 50, 60, 70 years that this statute has existed, no one has ever argued before that somebody who's providing the services that are outlined in subsection A of the statute we're talking about, 62.323A1, nobody has ever argued that when you do those things, you can do that without regulatory oversight. We think the commission was very correct when it decided that they needed to go the additional step and decided if Yadkin was not just a landlord, but a landlord that also provided utility services. And I think I about used up my time, and I thank the court for its attention.
All right, thank you, counsel. Any rebuttal?
Yes, Your Honor. First, I want to go back and further address your hypotheticals. And in fact, Duke made the argument that this would give rise to situations comparable to what you're saying, merchant plants in particular, that would spring up around North Carolina. That's addressed on pages 24 to 27 of our reply brief, and I'd urge those on the court. But in a nutshell, what they say is, and what Duke doesn't say in its arguments that this is replicable all over North Carolina, is that North Carolina law and the regulatory process would prevent that. And in fact, it would prevent both of your hypotheticals, Judge Dietz. In the billion-dollar company example, you can't build a generating facility without a certificate issued by the commission. So that couldn't happen. And with regard to Jones Electric, a spinoff where it deregulated itself, again, a public utility can't deregulate itself without commission approval. Both of those things would require that. The fact is, Cube's facilities and its situation are unique in North Carolina. It's a vestige of days gone by. No, not once during the course of this case have Duke or any of the amici pointed to any comparable situation anywhere in North Carolina. And so the notion that the sky will fall or that Chapter 62 will cease to exist as we know it for utilities regulation because Cube does what it does is just not supported by, quite frankly, anything. Duke fails to grapple with the statutory construction issues here. They point to policy. But the fact is, as Lumbee said, this court is not allowed to superimpose conditions on a specific exception statute that don't exist. The General Assembly has imposed conditions, 2 of them. You can't sell metered, and the tenant can't resell. That's all the General Assembly chose to impose here. With regard to the notion that this is a narrow exception, only for the purpose of allowing a landlord to buy from a public utility and resell to its tenant, of course, the statute doesn't say anything close to that. But if you look a few sections later in 23G, the statute does contemplate just such an exception. It says, the term public utility shall not include a hotel which imposes charges to occupants for local, long distance, or wide area telecommunication services when such calls are completed through the use of facilities provided by a public utility. The General Assembly could have said that in 23D. It did not. Your Honor, The notion that this is some kind of a sham lease or that this is for some evil purpose is just not borne out. Again, the public staff in its comments said the public staff's reading of the draft lease is that there's nothing fictional about it. It would be a full service lease in form and substance. It would be a lawful lease as proposed. And the fact is, different commercial tenants will have different needs depending upon their business. A distribution center will need a lot of land. A bottling company will need access to clean water in volume. High computing technology companies require a lot of electricity. The relative scale of those components doesn't destroy the landlord-tenant relationship. The distribution company, the bottler, the tech company are all equally leasing a property that meets their needs. I think my time is up. Is that right, Your Honor?
That's right. Well, thank you, counsel. Thank you both for your arguments. We'll adjourn. Mr. Soar?
This session of the North Carolina Court of Appeals is now adjourned.
All right, thank you both. We appreciate your arguments. You're free to drop off now at any time. You can treat it like virtually leaving the courtroom. Thank you.
Thank you, Your Honor.
Very much. We appreciate your help.